Let's explain those Badlands. That's a hell of a name.
Welcome to the No Treason podcast. This is episode 21. I am your host, Jonathan Drake. This is a pre-record. I will have to work when this airs on Sunday night. Actually recording this a little bit before Only lands on Friday. I will be live next Sunday, God willing. And I'm going to try another call-in portion. I got some new gear. We'll give another method of taking calls / in quotes calls. With this new device, there's a service that it provides. I can also do, I think, what CanCon does by routing a Google Voice number, and I set one of those up. But I'm going to try this other service as well and see which one works best for that. We'll figure all that out next week. But last week, we wrapped up the second part of a two-part mini-series on the nature of criminality, which is an important topic because, as it turns out, abdicating, such as we have done, the authority to adjudicate as the people what crime actually is, has opened the door for the most subtle yet effective tyranny imaginable, allowing the government to determine by statute what is crime versus intent. So intent, not statute, under a natural law system is the primary determiner of crime, and the jury, exercising their natural right of resisting tyranny, is the only lawful ascertainer of the intent of the accused, and therefore the criminality. Criminality by statute has, as a consequence, which is a feature, not a bug, the total erosion of liberty. And how is that? We talked about this last week. If part of your preparations for opening a business, building something on your own property, traveling, etc., is to check what regulations you must follow, what licenses you must obtain, what identification you need to carry with you, what sort of taxes you must pay, and so on. In other words, obtain the permission of the state to do what is yours to do by right under natural law. Then you are not free. You do not have liberty. And I don't care, as annoyed as people will get at me for saying things like this, I don't care what you claim to be celebrating on July 4th, because it clearly, definitionally, is not true. It's a worthy goal. I want to live in a free country. We don't have a free country. So let's just stop pretending. I've used the phrase a number of times that my older brother used to like to use regarding euphemisms, that a euphemism is just a euphemism for lying. And how have they done this? How have they taken away our liberty in such a manner? What is the maxim that the legal system has concocted to justify its stranglehold on our courts? And it is ignorance of the law is no excuse. This maxim has replaced intent, mens rea, the guilty mind, as being the primary basis for determining criminality. And our acceptance of this demonstrates that we are subjects of a regime, not masters of a servant, as we imagine ourselves to be when we step outside a polling station, proudly slap that I voted sticker on our shirt, and then go home to watch the TV tell us who won the fake election and if our team now holds the sword. I didn't emphasize this aspect of this last week, but I quoted Spooner as saying, and let me go ahead and pull this up, to get rid of the necessity of showing a criminal intent and thereby further to enslave the people by reducing them to the necessity of a blind, unreasoning submission to the arbitrary will of the government and of a surrender of all right on their part, that is the people's part, to judge what are their constitutional and natural rights and liberties. Courts have invented another idea, which they have incorporated among the pretended maxims upon which they act in criminal trials. That is, that ignorance of the law excuses no one. And this bogus maxim, that is, that ignorance of the law excuses no one, is indispensable for this purpose, the purpose of upholding their arbitrary right of authority. It's indispensable for that purpose because if it be once admitted that the people have any rights and liberties which the government cannot lawfully take from them, then the question arises in regard to every statute of the government, whether it be law or not. What does it truly mean to that we have the right to judge what our constitutional and natural rights and liberties actually are? What does it really mean? What does it mean that we have rights that the government cannot lawfully take away? Who gets to decide that? How is that decided? Do we really believe that we have that right? Or was that all done 250 years ago and we no longer have a say in the matter, but just have to live with whatever the founders illegitimately founded? If you go back to the No Treason essay, that explains that thoroughly. And what has been subverted and expanded and morphed and changed ever for the worse in the centuries since. And we're now just without a say. And we just have to live with what we've got, the so-called greatest experiment in human liberty in history. Or is our say accomplished at the ballot, as some would like to believe? The question I have for that is, how well has that worked for the last nearly 250 years? What do you suppose of, for, and by the people really means? What are we really having a say about? How do we truly express our supposed belief of being the true power behind the government, as we rightfully so verbally affirm that the only legitimate government is one that governs by the consent of the governed? I've been contending that the only viable expression of that truth of, for, and by, of having that say in what our rights and liberties are, is by demanding a restoration of trial by jury as the adjudicator of the law, the final tribunal, the final boss, as it were. And as long as we have the optics of trial by jury, which we still do, thankfully, then we should use it the way that it was meant to be used, and nullify, baby, nullify. That, of course, is the long game, at least in my mind. It won't happen overnight. But as long as we personally stay true to those concepts, teach them to as many people as we can, I believe over time, we can actually turn the tide against the subtle tyranny that we've been subjected to in the endless litany of statutes that criminalize things that we have a natural right to do without permission, which is the very foundational understanding of what a natural right actually is. Now, something else I wanted to clarify was this from last week. I realized even as I was saying, there was some confusion, I think, that could come from this. And so I'm going to play a clip from last week, and we'll discuss it afterwards. An agent who had come to aggress against those natural rights, and they were in perfect rights of self-defense to do so, and a trial by jury properly handled would have the opportunity to protect that person and send a warning to law enforcement agents who may be doing something out of, they're doing something that is, they're not trying to be criminal. Oh, that stopped playing for some reason. Okay. Peculiar. Technical difficulties. All right. So the line that I was trying to emphasize there was they're not trying to be criminal, but they're engaging in inherently criminal acts. So this was in context of someone defending themselves against a sheriff or other law enforcement agent who's coming to enforce tyranny. So the sheriff or the police officer who comes to enforce tyranny, I'd say that they're not necessarily trying to be criminal. They're not trying to be malicious. And that may be true. They may not be. They're just trying to do, they may well believe that what they're doing is the right thing. They're doing their job. They think they're upholding order in society or whatever. But if what they're doing is violating your natural right, then by right, you have the liberty to defend yourself. And that point Spooner makes very aggressively, that the jury would be able to acquit a person for defending themselves. Because in that moment, when that officer comes, you don't know if that officer is operating with criminal intent. You're just trying to defend yourself or your property. Other examples that I raised to drive this point home in the last couple of weeks were like if you owned a farm with, chickens or cows or any other type of farm animal, and the state has decided that those animals pose a risk and they want to come and kill your animals, thereby destroying your livelihood, you would have a right to defend your property. And you would have that right in the same way you would if someone broke into your home uninvited in the middle of the night or whatever. There's no difference. Except in a situation where crime is by statute, then they're going to take that away from you. And that is the basis of the destruction of liberty through a criminal system wherein criminality is determined not by the jury, but is determined by the state. Successfully defending yourself and getting enough of a jury to agree with you would serve as a sufficient warning to other officers to not be party to tyranny. I said this last week too. If you're someone in law enforcement and you understand these concepts and you really genuinely care about liberty, the obvious answer is stop enforcing tyranny. Stop being the tip of the spear. I've used this phrase before, and I've said this for many, many years, that the tyranny is only as effective as the boots on the ground are willing to make it. So if you're one of those boots on the ground, stop making it effective. That was last week. So tonight, we'll begin to cover Spooner's chapter Objections and flesh out further his vision for what he and many others have referred to as the Palladium of liberty. But first, we have a word from Benson Honey Farms, one of the OG Badlands sponsors. Welcome to Benson Honey Farms, where every jar is pure gold. Benson's Honey is excited to be back on Badlands Media with their latest 2025 honey harvest, straight from their farm in Nebraska. While they've been busy working to improve our state politics from the ground up, they never forgot the importance of sharing the best honey around. Did you know honey isn't just a sweet treat, it's nature's medicine? Perfect for alleviating allergies, soothing upset stomachs, or as a delicious natural sweetener for baking. Benson Honey is never heated, ensuring you receive it in its pure, raw form, full of natural goodness. At Benson Honey Farms, quality and purity is top priority, and they're committed to providing the finest honey from hive to home. Join the supportive community and enjoy a special offer. Visit badlandsmedia.tv/honey and use promo code BADLANDS for 15% off your purchase. Benson Honey Farms, savor the authentic taste of Nebraska and support this America First business. You can follow them on Facebook at Benson Honey Farms. And I won't pretend to be any sort of a baron. That's my first opportunity to have them on the show. The next sponsor we've got is, well, let's remove that and put this up instead. There we go. Technical difficulties, my goodness. Make America healthy again yourself. So maha yourself. Savor. I got my ad reads all next to each other. So make America healthy again yourself with supplements that don't suck from Conscious Strength. Founded by Badlands' very own Jordan Sather in 2019, Conscious Strength products are made in America and won't break your bank, unlike other online brands. Their lineup includes collagen for strengthening joints and hair, electrolytes to get rid of those cramps, greens powder that tastes good and mixes easy, Shilajit gummies, methylene blue, zeolite, and more. Flip the finger to pharma. Be your own doctor and get supplements that you can trust from Conscious Strength. Go to badlandsmedia.tv/strength to shop now. That's badlandsmedia.tv/strength. And there will be a link to that in the description for this show, so I'm told. The next sponsor is a word from an incredibly dangerous woman. A lovely woman, but a dangerous woman.
In a quiet town at where beards grow wild and lips dare to crack without permission, one woman has suffered.
Hi, I'm Margie, and I'm Jadriet's mother.
But the world would come to know her by another name, Madame Margie, the moistureless.
Jay came home with a lip balm. It's called Soft Disclosure.
With one miraculous application, her power awakened.
Within one day, my lips were healed. It was miraculous.
But salvation came at a cost. For in the shadowed lands known only as Badlands,
You boys at Badlands are so handsome.
she saw potential,
You're covering up your beautiful faces.
and she made her demand,
Shave them all off,
or face the consequences. Beard oil will not save you now.
and you'll look so much better.
This summer, moisturize wisely and guard your beard, because Madame Margie, the moistureless, is always watching.
I wonder what the consequences would be for not shaving my beard. I won't be shaving my beard, so I guess I'll find out. The last sponsor we have for this evening is Great American Restoration Tour number 11. GART Nashville, coming up April 9th through 12th. And if you read through the list of featured speakers, you will come to one conclusion, and that is they have really lowered their standards. Because there I am, right there in the middle. I will be at GART. I will be one of the paneled speakers. I'm really looking forward to that. If you are able to come in person, I believe there are still first in-person tickets available. But if not, right now there is an early bird price going on for virtual tickets. That is through March 15th. So for the next few weeks. And after that, the regular price of $40 will come into play. Virtual is obviously not as good as in person, but you get access to the Telegram channel and can see some of the behind the scenes video and all of that. And as I've mentioned, Ash and I, along with CanCon, are working on a trial by jury immersive experience to help drive the point home that trial by jury is the Palladium of Liberty. And that will be for in-person attendees at Nashville coming up April 9th through 12th. So go to badlandsmedia.com or not .com, badlandsmedia.tv/events to get either your virtual tickets or your in-person tickets. All right, let's bring that back, remove that, this and that, and other things. All right, so let's talk objections. This is in chapter 5, I believe, titled Objections from Lysander Spooner's Trial by Jury. So the first one we have, Objection number one. There are in this chapter there are 5 objections. We'll cover the first 4 tonight. The fifth one is rather lengthy, and it's kind of a mini treatise in and of itself. Excuse me. But objection 1 is that it is that is a maxim of the law. That it is a maxim of the law that the judges respond to the question of law and juries only to the question of fact. This is something that you will encounter today. It is present in all sorts of legal writings over the last almost 200 years. And Spooner's just reply to this objection is that judges and the controllers of the legal system have had centuries to invent all sorts of maxims to justify their overreach. All those maxims do, especially this one, is, as he writes, express nothing but the ambitious and lawless will of the judges themselves and of those whose instruments they are. And my thoughts on this is that this maxim that judges respond to the question of law and juries only to the question of fact, it doesn't even attempt to make an argument. It provides no rationale. It just makes a statement and expects you to comply. But why is it a maxim? What makes something a maxim? From where does a judge derive this authority to establish such maxims? Practically speaking, their ability rather than authority currently stems from, that's just the way it is. And they'll make your life hell through the help of the boots on the ground unless you agree with them. That's not a moral position. That's might makes right, which arguably so is the way a lot of things actually work, but it doesn't make a moral argument. That is not a moral position. And if our goal is to be a moral country, moral people, then we should eschew immoral arguments, immoral practices. And I would argue that this statement, this concept of judges basically declaring for themselves what they think is correct, that's not a position congruent with the founding ethos of this country. But as we saw in No Treason, nothing about this government has ever been congruent with the founding ethos of this country. And the sooner we disabuse ourselves of any notion that what the founders created is worth keeping, understanding that what they created entirely contradicted what they purportedly professed to believe, that the government rules legitimately by the consent of the governed. They said they believed that, but we don't actually have that. So the sooner we disabuse ourselves the notion that we have that, the better. On this maxim, Spooner has a footnote, and he writes, judges do not even live up to that part of their own maxim that they respond to the question of the law and the jury responds to the question of fact. So they don't even live up to that part of the maxim, which requires juries to try the matter of fact by dictating to them the laws of evidence. That is, by dictating what evidence the jury may hear and what they may not hear, and also by dictating to them the rules of weighing such evidence as they permit them to hear. They, that is the judges, of necessity dictate the conclusion to which they shall arrive. That is, they, that being the jury. So by controlling the flow of evidence, the judge is able to curate how the jury will likely respond. And thus, the court really tries the question of fact as well as the question of law in every cause. It is clearly impossible in the nature of things for a jury to try a question of fact without trying every question of law on which the fact depends. And the obvious thought here is that if judges can't even follow their own maxims, then why should we trust them to be the gatekeepers of liberty, which they truly are, since a law is only meaningful to the extent it is enforced, which is the entire foundational concept behind trial by jury, where we, the people, decide, going back to the quote that I brought back up again in the recap from last week, that we get to decide what our liberties are and what our rights are. And the best way to do that is we are the ones who decide what laws actually get enforced. So it doesn't matter if you have a king or a Congress or whatever else. You want to call it a republic if it makes you feel any better, or a democracy or whatever. If the people are the ones deciding what actually gets enforced, that is where the rubber meets the road as far as liberty is concerned. Moving on to objection number 2. It will be asked, of what use are the justices if the jurors judge both of law and fact? Spooner writes, the answer is that they are of use, 1, to assist and enlighten the jurors, if they can, by their advice and information. Such advice and information to be received only for what they may chance to be worth in the estimation of the jurors. So they're not dictating, they're just saying, hey, this is what we think. 2, to do anything that may be necessary in regard to granting appeals and new trials. We've covered the first part before. But point 2 is a little bit odd to me. Spooner doesn't really elaborate in this place on this idea. But first reading, it kind of seems like a slippery slope that he's agreeing to, that the jury or the judge or the justices or officers of the court would have a say in granting appeals and new trials and such. And this may have been the case historically. He makes that case. But while the Anglo-Saxons were probably the most successful implementation of trial by jury, there's no reason to assume that what they did can't be improved on. So we don't have to only stick with what they have. If we can come up with better ways to implement the basic first principles, then I'm okay with that, as long as those first principles are being honored. But there are elements in the next objection that indicate Spooner was sympathetic to the government being duty-bound to not execute the judgment of a jury if the jury decided something contrary to natural law. So the initiation of appeal could be done by the government in that case. Spooner thinks that's a rare situation, but both the judge and the jury are clearly oaths are meaningless, but by oath, the justice or the judge was bound to adhere to natural law, to common law. And so if the jury, for whatever reason, didn't seem to be going along with that, the judge had a responsibility to pump the brakes, as it were. And we'll get into that here in objection 3, which is coming right up. Objection 3, it is said that it would be absurd that 12 ignorant men should have power to judge of the law, while justices learned in the law should be compelled to sit by and see the law decided erroneously. This is some of the answer to Claire's question a few weeks ago was answered from this objection, as well as the next. And the first answer that Spooner gives is that the power of a jury is not predicated on the supposition that they know the law better than the justices, as he says. The law here isn't necessarily natural law, but the arbitrary system of statutes. And of course, the judges and the lawyers and the officers of the court would know that better than the common people who don't take the time to research these things in general. And these officers of the court and juries or judges and lawyers, they created it. I should have looked this up, but I wonder what the total percentage throughout the entirety of American history, what percentage of representatives have been those with a legal background, lawyers or whatnot. So it makes sense that, and there's in the libertarian community, and not the stupid Libertarian Party, but just libertarian thought, Murray Rothbard, guys like that, lawyers were looked on with high disdain because of their part in creating this ridiculously complex system, which is something that Spooner will get into in objection 5, which we'll cover next week. It could be natural law that's being discussed here. The justices learned it in the law. You could have a guy who's really, really deeply committed to natural law and has really thought it through. Like, imagine if Lysander Spooner himself were a judge, I would trust his advice over my own in this case. But either way, if it is natural law, the jury, according to Spooner's writings in the Science of Justice essay, the jury has learning enough to judge by it because everyone basically understands the basic tenets of natural law. And if you think about the things that we know to be true, and that's maybe a rather limited scope, that tells you that the law would have a limited scope as well. And there's a lot of things that we have laws about that we don't need to have laws about because in general, they're violating our natural rights anyway. So the power of a jury is not predicated that they know the law better than the justice is, but rather it's on the grounds that centralization of authority and power, when you look at this concept throughout history, always leads to problems. Centralization is a clear theme of the global regime, as Chris Paul likes to refer to it, and they are always pushing for it. And I'll touch on this more here in a minute. By virtue of being centralized, the power of the jury is predicated. So the centralization of authority. So by virtue of it being centralized, the power of the jury is predicated on the ground that the justices are untrustworthy. So the power is centralized in justices, which means the power of the jury is even more important because these justices, by virtue of being centralized, are untrustworthy. That they are exposed to bribes, are themselves fond of power and authority, and are also the dependent and subservient creatures of the legislature. And that to allow them to dictate the law would not only expose the rights of parties to be sold for money, but would be equivalent to surrendering all the property, liberty, and rights of the people unreservedly into the hands of arbitrary power, that is, the legislature, to be disposed of at its pleasure. And I meant to pull that up. My apologies. Basically, why on earth would we entrust our liberty into the hands of a centralized authority who assumes the power to determine for itself the rules of any interaction we have with it, and which reserves the right of veto for itself? Be like, I audited myself and I passed. Think back to last week's discussion on how criminality by statute destroys liberty. Always having to ask for permission to exercise your natural rights. If you have to ask for permission, you are not free. Decentralization, therefore, is the answer. A centralized authority doesn't want each individual deciding for themselves what their liberty actually is. That's not easy to control. That's not easy to tax and thus be able to borrow and tax more and make themselves and their handlers rich. They would say, we can't have people decide for themselves what their liberties actually are because they might choose to ignore us. Now, is what is being discussed here over this entire series, is it perfect? No. But like anything else in this fallen world, there are problems and there are solutions, some more or less effective. As for a solution, why do we want, or why would we want, to centralize authority and representation given the historical precedent that's been set by doing just that? What do we gain from elevating a small group of men to arbitrarily decide, give them arbitrary authority through easily sabotaged electoral systems? This isn't even mentioning the problems with what's actually being voted about. If you're voting to decide what happens to your neighbor's property, that's not a legitimate vote. You don't have a right to say what happens on your neighbor's property. And if you don't have that right, you can't delegate that right to someone else, which means if by voting you're doing that, you are becoming part of that secret band of robbers and murderers, as Spooner liked to call them in No Treason, the Constitution of No Authority essay. And you become part of that secret band of robbers and murderers, robbing and murdering from your neighbor, aggressing against their natural rights. That's the problem I have with voting. Jurors, by virtue of their temporary nature and other reasons we've discussed, are less likely to be bribed or tempted. They have to return back to live amongst their neighbors and give account for how they judged in that trial. Being a juror doesn't generally bring you fame, glory, or power. It's not a long-standing position. Of course, the question that Claire had asked was, what if they're partisan? What if they don't share my values? That's a question that people are having in regards to immigration issues. To that, Spooner writes that the laws of human nature do not permit the supposition that 12 men taken by lot, that is completely random, from the mass of the people and acting under such circumstances will all prove dishonest, or will all prove to not have your values. It is a supposable case that they may not be sufficiently enlightened to know and do their whole duty in all cases whatsoever, but that they should all prove dishonest is not within the range of probability. And this goes back to what a justice system should be in service of justice. We are used to the legal system of today as it is used to enforce the never-ending breadth of fiat statutes and the subsequent Pavlovian reaction of always seeking permission. But that's not justice. That's not peace. That's not liberty. And this is a case of interpreting what Spooner is talking about in context of a bloated system that needs an enema. We talk of a tax revolt, which would be lovely. At some point, we should also talk about a judicial revolt, because tax laws have no teeth if juries won't convict. That's going to take personal decisions by each person. If you happen to be able to get onto a jury, even in this currently perverted system, you could still effect liberty by acquitting people of laws that violate their natural rights. Moving on to objection 4. Objection 4 is, it is alleged that if juries are allowed to judge of the law, they decide the law absolutely, that their decision must necessarily stand, be it right or wrong, and that this power of absolute decision would be dangerous in their hands by reason of their ignorance of the law. So this kind of ties back in with the objection that the judges are more learned in the law, so it's ridiculous to think that a jury with these just regular people could have a say. And people would argue that this is a danger, allowing those people to have a say, because what the jury decides, that decides it. Spooner has an interesting answer to this. He says one answer is that this power, which juries have of judging of the law, is not a power of absolute decision in all cases. For example, it is a power to declare imperatively that a man's property, liberty, or life shall not be taken from him. But it is not a power to declare imperatively that they shall be taken from him. Then he ties this back to Magna Carta. Magna Carta does not provide that the judgments of the peers shall be executed, but only that no other than their judgments shall ever be executed, so far as to take a party's goods, rights, or person thereon. Spooner points out that the trial by jury's primary allure isn't that the government is required to perform the judgment of the peers. Rather, its primary allure is that the government may not execute any other judgment, which automatically destroys the entire statutory criminal system shrouded by the civil layer, which many cases of you being stolen from and aggressed against happen on that civil layer. It is the de facto veto power of the people. If this power of absolute decision would be dangerous in their hands, that is, the people from whom the judges ostensibly derive their power, then it is most certainly dangerous in the hands of a few selected men and women. So this is an objection that just blows right back on them. If the government should overstep its bounds and start enforcing judgments that are not properly rendered, proper meaning by jury and not by statute, then Spooner's answer, and the founders' answer as well, is that the people must employ other means of exercising their natural right to resist tyranny. This is why Spooner connected trial by jury as co-equal with the Second Amendment, the purpose of which is, of course, given much lip service, but we don't really believe that. But moving on. You might think that the government not being bound to execute the judgment of a jury, even upon appeal, to be a fatal flaw with this system, but Spooner wisely points out, if the government had no alternative but to execute all judgments of a jury indiscriminately, the power of juries would unquestionably be dangerous. For there is no doubt that they may sometimes give hasty and erroneous judgments. I'm blanking on the term. It's judgment in lieu, or Claire Cat has brought this up, and it's judgment in lieu of a verdict or something to that effect. That's been used in a negative case, in that Minnesota case in which a jury convicted Somali of fraud, and then the judge said they didn't like that. That is a potential outcome where the government is not required to actually execute what the jury says. But the key difference here, and the reason why this is considered the Palladium of liberty, is that the government is not allowed to execute a judgment without a jury's verdict. And so that's something that would have to be parsed through, and each community would have to work that out for themselves. So this is just understanding that there might be hasty or erroneous judgments. This is just a basic acknowledgement of the imperfection of human existence in a fallen world. Again, I said this is not a perfect system. It's certainly better than what we have, though. The availability of appeal and review by a further jury, in Spooner's mind, negates or at least strongly softens this concern. It was, even in the Anglo-Saxon system, we have it in our own system. There was a system of appeals that was enabled to protect the potentiality of a perverted jury. But simply because it isn't likely that there would be many cases that were that confusing or difficult to parse through that resulted in justice not being done, as far as it softening the concern. Spooner sees that it is a possibility, but it's not a high likelihood. But again, it should be stressed that the government, the executioner, as it were, may not swing the sword without the judgment of a jury. Think of this like an old arcade game. You can be the little kid sitting there hitting the buttons on the pinball machine, but unless you put the quarter in, it's not going to actually work. So you can think of the government or the judge as being the pinball machine, and the jury being the one placing the quarter into the machine. Spooner calls this active injustice versus active justice failing to be done. So active justice, the jury might get it wrong, therefore justice is not actually properly rendered. But if the government is allowed to swing the sword without the verdict of a jury, then that would be active injustice. It is reasonable to suppose that on more serious judgments like that of murder involving the death penalty, that a community would want there to be layers of review to prevent an innocent person from being wrongly executed, and I don't think any one of us would find objection with that. So in this, the Magna Carta does provide some insight in preventing perpetual retrials. Because this, well, what if they just keep appealing and appealing and appealing? The government may not execute a judgment without a jury, but the government is also bound by its purpose of justice and right to not execute a judgment that violated natural law. In this way, the government, properly rendered, could serve as a check on an unlawful jury, as unlikely as that would be. But still, given the role of the jury as trial by country, and thus supposing that its verdict is the law that the entire people, the country, want to have enforced upon them, ultimately, the jury has precedence. So this power of the government is not absolute. we've seen it become absolute, so there's been a role reversal. Of course, there's an obvious potential problem. What if the jury can't ever agree? What if the advice of the court, let's say the advice is good and lawful, advice. Lysander Spooner's sitting there as the justice, and he's like, let me tell you guys. But what if that's repeatedly ignored? Spooner's answer is justice would fail to be done. And he says, such a case is perhaps possible, but if possible, it can occur but rarely. Because although one jury may disagree, a succession of juries are not likely to disagree. That is, on matters of natural law or abstract justice. If such a thing should occur, it would almost certainly be owing to the attempt of the court to mislead them. You may quibble with that or not, but that's his perspective. It is hardly possible that any other cause should be adequate to produce such an effect, because justice comes very near to being a self-evident principle. The mind perceives it almost intuitively. If in addition to this, the court be uniformly on the side of justice, it is not a reasonable supposition that a succession of juries should disagree about it. If therefore, so the court advising them and being like, this is natural law, this is what we should be, it's not likely that a succession of juries would continually reject that. If therefore a succession of juries do disagree on the law of any case, the presumption is not that justice fails of being done, but that just injustice is prevented. That injustice, which would be done if the opinion of the court were suffered to control the jury. We see this in the Tina Peters case or whatever. The opinion of the court was suffered to control the jury, and in that case, injustice was done. Now, this may not satisfy you, and Spooner acknowledges that. And his answer is, for the sake of the argument, however, it may be admitted to be possible that justice should sometimes fail of being done through the disagreements of jurors, notwithstanding all the light which judges and lawyers can throw upon the question in issue. If it be asked what provision the trial by jury makes for such cases, the answer is it makes none, and justice must fail of being done from the want of its being made sufficiently intelligible. If the lawyers or counsels in the case aren't able to convince all 12 members of the jury of a certain way that the case should go, then, and in that case, justice actually doesn't get done. That's not active injustice. That is just basically inactive justice, or inactive injustice, how you want to put that. And Spooner's fear of a tyrannical government raining terror and active injustice onto the people, in his mind, is a far greater problem. And he's willing, and frankly, so am I, to risk the rare but potential outcome of justice failing to be done, rather than submit to the near guarantee of regular injustice being done with a court-mandated fiat law-based system. He writes, under the trial by jury, justice can never be done, that is, by a judgment that shall take a party's goods, rights or person, until that justice can be made intelligible or perceptible to the mind or the minds of all the jurors, or at least until it obtain the voluntary assent of all, an assent which ought not to be given until the justice itself shall have become perceptible to all. You have to convince the entire jury. Unanimity is imperative. Now, we'll spend the rest of the time tonight. We're going to go long again. So my apologies to Burning Bright in the narrative on his return at the turning of the tide, maybe. We'll spend the rest of the time tonight on this fourth objection, because it's a long one, as well as number 5, which we'll cover next week. Because really, Spooner's just getting started answering this. He writes, the principles of the trial by jury then are these. 1, that in criminal cases, the accused is presumed innocent. 2, that in civil cases, possession is presumptive proof of property. I forgot the expression, but possession is I forgot what percentage of the law, like 9/10 of the law or something like that. Or in other words, every man is presumed to be the rightful proprietor of whatever he has in his possession. 3, that these presumptions shall be overcome in a court of justice only by evidence, the sufficiency of which and by law, the justice of which are satisfactory to the understanding and consciences of all the jurors. But someone will say, if these are the principles of the trial by jury, then it is plain that justice must often fail to be done. Spooner writes, admitting, for the sake of the argument, that this may be true, the compensation for it is that positive injustice will also often fail to be done, whereas otherwise it would be done frequently. This goes back to the purpose behind trial by jury as the Palladium, the protector of liberty, and the liberty being most threatened by a centralized government. And again, Spooner would rather suffer the occasional failure of justice being done than the provably consistent positive injustice being done constantly as we have in our current system. He follows up with a thought that we've covered a couple of weeks ago, that essentially paralysis by analysis of trying to perfect an imperfect task will lead to its own set of problems. That the potential for some problems isn't an excuse to not take some precautions against tyranny, which trial by jury is. And we've not in our lifetimes given true trial by jury a legitimate try. So the claims of failure of that system are at this point mere hypotheticals. Whereas the actual abuses of the current system and any historical system similarly absolute and irresponsible are experienced reality. And again, it is more preferable to prevent positive injustice, that is, active injustice, than it is to have the occasional failure to effect justice. Some people might end up not getting the justice that they were seeking, but those would be a small number relative to the people that we have today who are continually having injustice done upon them. Spooner brings up a deeper reason as to why the risk is not only acceptable, but actually preferable. Because under trial by jury, trials are isolated events. So if in one trial the details are so muddied, or the community is so dysfunctional that justice fails to be done, maybe even on a regular basis, then a national precedent, which is treated as law and applied in all cases, is something that we could avoid. The failure to do justice in one case doesn't become the positive injustice in all cases, because in each case the jury judges by their consciences and not by fiat law. What did that other jury decide? Well, I don't agree with what they did over there in Minneapolis or Chicago or LA or New York or wherever. So I'm going to judge based on what I think the law is. So you're not bound to whatever jury or whatever a judge decides hundreds of miles away and in a completely different communal context. In that way, the parts of the country that aren't retarded will have their unique opportunity to make sure such retardation isn't nationally applied. Again, this goes back to decentralization. The global regime might capture certain communities and certain cities, but they would have to capture each and every single one in order to effect their tyranny. And if the majority of the communities are quite happy to not enforce tyrannical laws, then their entire program is defeated before it really even gets going. And Spooner says, no permanent law would be established, thereby destructive of the rights of the people in other like cases, and the people at large would continue to enjoy all their natural rights as before. This is just an unfortunate reality living in a fallen world. Nothing is going to be perfect, but in this way, it's able to isolate the retardation. And this inability to effect justice can be for any number of reasons. Spooner mentions that maybe the plaintiff and the defendant This is maybe a jury's not able to reach a decision, or they reach the wrong decision. Maybe the plaintiff and defendant conducted their business or their relationship in such a manner as to make it nearly impossible to fairly parse things out. If it comes down to a he said, she said kind of a thing, and you're just like, well, I mean, which one's right? In that case, you fall back to the maxim that that Spooner referred to earlier, that possession is the presumptive proof of property. The jury wouldn't be justified in taking the property of one and giving it to the other unless justice were amply clear. And that would serve then as a warning. We may not take the way the jury decided in this other case, say Minneapolis or any of the other places that have lots of immigration and different ideologies floating around. We may not take the way that they decided things, but we can learn from that case, and we can learn, hey, you know what? Maybe I should be more intentional in the way I conduct my business relationships. When I, buy something, I'm going to keep receipts. When, that's one aspect of Bitcoin that is awesome, because you can codify things in a way that is indisputable. They can't go back and change it. And ultimately, that puts the onus of protecting oneself where it belongs, with you. Spooner writes, the difference then between the two systems is this. Under the one system, a jury at distant intervals would not enforce any positive injustice, but only fail of enforcing justice in a dark and difficult case, or in consequence of the parties not having transacted their business in a manner intelligible to a jury, and the plaintiff would thus fail of obtaining what was rightfully due him. And there the matter would end, for evil, though not for good. For thenceforth parties, warned of the danger of losing their rights, would be careful to transact their business in a more clear and intelligible manner. Under the other system, the system of legislative and judicial authority, the one we live in now, positive injustice is not only done in every suit arising under unjust laws, that is, men's property, liberty, or lives are not only unjustly taken on those particular judgments, but the rights of the whole people are struck down by the authority of the laws thus enforced, and a wide-sweeping tyranny at once put in operation. This goes back to centralized versus decentralized. The centralization is the weapon, the aim, the goal, the tool of the global regime. And decentralization is effectively the Palladium of liberty. So you can use that as a first principle to analyze any system that is being pushed forth and ask yourself, is this centralizing power or is it decentralizing power? And if it's centralizing power, it's probably not a good thing. It's probably being pushed by forces you don't want to stand shoulder to shoulder with. And to that point, during election season, when you're talking about getting out the vote and you look to your right and you look to your left and you see a bunch of leftists, to use that rather diluted term, a bunch of Hollywood actors and a bunch of blue-haired land whale activists all screaming, let's get out the vote, you might be pushing for the wrong thing. My 2 cents. Spooner writes, but there is another ample and conclusive answer to the argument that injustice would often fail to be done if jurors were allowed to be governed by their own consciences instead of the direction of the justices in matters of law. That answer is this. Legitimate government can be formed only by the voluntary association of all who contribute to its support. Of all, mind you. As a voluntary association, it can have for its objects only those things in which the members of the association are all agreed. If therefore there be any justice in regard to which all the parties to the government are not agreed, the objects of the association do not extend to it. When you're speaking of an institution that is empowered to deprive a person of their life, liberty, or property, everyone connected with it must agree. Majority does not cut it. That's why a jury needs to be unanimous. Spooner has a chapter, which we will cover, and I'm looking forward to that chapter, on majority rule and what an absolute disaster that concept is. Spooner writes that justice is the object of the government, and those who support the government must be agreed as to the justice to be executed by it, or they cannot rightfully unite in maintaining the government itself. This is what we say we believe. No taxation without representation of, for, and by the people. But if you consistently apply those principles and dutifully keep yourself within their logical bounds, then by definition, a government of the whole, therefore, must necessarily confine itself to the administration of such principles of law as all the people who contribute to the support of the government can comprehend and see the justice of. This is why unanimity is essential. This is why the jury must be the final tribunal to declare what will or will not be enforceable as law. Why? Because the people at large, the unlearned and common people, have certainly an indisputable right to associate for the establishment and maintenance of such a government as they themselves see the justice of and feel the need of, for the promotion of their own interests and the safety of their own rights, without, at the same time, surrendering all their property, liberty, and rights into the hands of men who, under the pretense of a superior and incomprehensible knowledge of justice, may dispose of such property, liberties, and rights in a manner to suit their own selfish and dishonest purposes. This is the founding ethos. This is what we say we believe. But this is not what this system actually acts upon, which means it's their system. It's not our system. The conclusion, therefore, is that in a government formed by voluntary association, or on the theory of voluntary association and voluntary support, as all the North American governments are, speaking also of the states, no law can rightfully be enforced by the association in its corporate capacity against the goods, rights, or person of any individual, except it be such as all the members of the association agree that it may enforce. And I did not create a slide for this last quote, but Spooner writes, to enforce any other law to the extent of taking a man's goods, rights, or person would be making some of the parties to the association accomplices in what they regard as acts of injustice. It would also be making them consent to what they regard as the destruction of their own rights. These are things which no legitimate system or theory of government can require of any of the parties to it. This should be, not that there should be public schools, but this should be American Civics 101. This is the logical outflow of what we say we believe. If we have the concept of representative government, but some people don't consent to be represented, just because you obtain a majority, quote unquote, vote in a quote unquote election does not give you the right to take a man's goods, rights, or his person simply because you represent a portion of the population. Think back to the no treason essay discussion and Spooner's discussion in section 2 about how voting doesn't provide consent. And the obvious maxim that one person may not consent for another person without that person's consent for them to be their representative. So a person sitting in the halls of Congress saying, I represent this district. No, you only represent those people who actually voted for you, not the people who voted against you, and certainly not the people that didn't participate in the electoral process at all. And because of the secret ballot, Chris and KenCon were talking about this on daily on Friday. Because of the secret ballot, you can't actually even prove that any one of those people actually voted for you. So you claiming to be a representative of somebody is bullshit. You don't. You can't prove in a court that derives its authority from the document that you say gives you your authority. You can't prove in that court that you're an actual legal representative of anyone. And if you walked into a court with a document like the Constitution or with election results, and you tried to use that as proof, they would throw you out because it doesn't meet the standard of proof that's used for basic power of attorney. If you want to get access to someone's bank accounts or be the person to make decisions in a medical situation, you have to have a legal document that is signed, going back to natural law, and it's been witnessed. And they can't do any of that for any of our elections. They're not legitimate. Even if you have full transparency, you aren't legitimate because you can't claim to represent a person that didn't actually vote for you. Majority rule is an illegitimate form of rule. It's not a moral form of rule, especially when you're talking about the government wielding a sword that could sever a person from their life or their property or their time. We have to think about these things. I contend, as I've been saying this for a while now, that representative government with representatives being selected by a majority vote, which is really a majority of the small minority of the actual affected population, it's a blatant violation of the things we say we believe, that the only moral government is a government that governs by consent of the governed. And we either need to realize that and cast off these Republican inconsistencies, and I don't mean Republican like the party, or Democratic inconsistencies. It's all the same thing at the end of the day. The same result is people being deprived of their life, liberty, and property simply because the majority voted that way. We need to cast that stuff off or just accept the reality that we're not actually a moral people and that we are, as Spooner writes, accomplices in what they regard as acts of injustice. Our goal is liberty. Our goal is not a system that makes us feel good. The goal is actual liberty, actual natural rights being honored, not seeking permission to build a shed to cover your firewood to keep you warm in the winter. That's what we have today. That's why the jury must be the deciders of intent. That's why the juries must be the deciders of what is actually enforceable law. If we leave that to the centralized government, centralization being the main focus, the main tool, the main emphasis of the global regime, the further it's centralized, the easier it is for them to control and affect their tyranny. Like I mentioned, if you have a city that is crazy right now and their juries are not going to be great, well, guess what? Your community doesn't have to be that way. And those people that are there can either clean up their act or they'll leave. Trial by jury doesn't care what system of government establishes itself, since at the end of the day, all those types of government, those systems, they're just different shades of the same despotic notions that they can tell you what you can do with your own property. This is why trial by jury is the palladium of liberty and why it must be our number one demand. I made the comment, it got read on, I dropped it as a rant. It was on the State of the Union coverage. The concept of the wolf and the lamb, if democracy is a wolf and a lamb voting on what to have for dinner or whatever. Well, saying that a republic, and Ash is going to feel attacked on this, I'm sure, because she likes to say that a republic is somehow an answer to this question. But if the end result of a republic, which is just essentially adding another layer of bureaucracy on top of essentially democratic rule, majority rule, really, Does transparency really matter to the lamb if the lamb is able to get full transparency on the vote of the wolves to have the lamb for dinner? And the obvious answer to that is, well, obviously not. The lamb being for dinner shouldn't be up for a vote, but that's exactly what we're talking about when we're talking about your life, liberty, and property being able to be taken away by the results of a vote. That means it's not it's violating your natural rights. That's not a right that those people have to vote for those things. And if we are participating in that system, ultimately we are becoming the wolves to our neighbors. And Spooner says we should not be doing that. And that's kind of an obvious answer because that's what we say we believe. So let's be consistent with that. Okay. Looking ahead, we've run a little bit long here. I imagine BB's intro is just now finishing up. Next week, we will look at Objection 5, wherein Spooner takes a deep dive into familiar territory by answering the objection, probably most cited by the regime as to why it cannot allow the common man veto power over its laws. And the objection is that another objection will perhaps be made to allowing jurors to judge of the law, and the justice of the law is that the law would be uncertain. And it is a long enough answer that he gives to that we'll spend the entirety of next week on that. As I mentioned, I'll be live next week. Thank you all for joining me tonight. Hopefully I was able to be in the chat. I intend to be, but you never know how life goes. But with that, I'll say thanks for joining me, and I'll see you all next week.
Why a spoon, cousin? Why not an axe?
Because it's dull, you twit. It'll hurt more.
Thank you so much for joining us, and don't forget to hit the thumbs up on this video. And a special thank you to all of our advertising partners. Please remember to shift your dollars to support those businesses that support Badlands Media.